All right, welcome back in Live Now. I'm Austin Westfall. Let's talk Google. Google has been branded an abusive monopolist by a federal judge for the second time in less than a year, this time for illegally exploiting some of its online marketing technology. The Associated Press says that Google's internet empire is currently worth $1.8 trillion. The DOJ originally targeted Google's ad network under the Biden administration in 2023. Tom Rosman is standing by. He knows a thing or two about these types of high-profile monopoly cases. He's with the Henry George School of Social Science in New York. Let's start with the very basics here. What exactly was Google accused of doing?
Okay, thank you, Austin. It's a pleasure to be with you tonight. Now, the government argued that the case that Google had in this situation is a monopoly over three parts of online advertising market. The tools used by online publishers like Fox News and news sites to host open ad space. The tools that were used to buy and sell that ad space, and the software that facilitates those transactions. Now, to kind of give you a bit of context, Google has a monopoly on this ad tech, which is a series of software that from start to finish, publishers and advertisers can come together to buy and sell advertising space on the internet. What it really does is line up the sellers and consumers with the ads they want to see. Now, this is significant because it's a $31 billion business for Google's ad business, and it matches these website publishers with the advertisers. And the stack really, to kind of apply it even more specifically, it applies to the banner ads that you see. So you do Google search on Fox, you hit up the site because you like the story, and the ads that you see on the top and on the sides are all determined by this ad tech stack that Google has. And it applies to countless sites across the web and the whole digital ecosystem that enables advertisers to place ads and for publishers to monetize their digital space.
So does Google get punished now, or is there likely a lengthy appeal process coming?
There's always a lengthy appeal process coming. And in this particular case, they did win one of the three motions, so they're emboldened even more to oppose it. But typically, for example, with the case against them with online search, they're actually moving next week. As a matter of fact, Monday, they're moving into the remedy phase where they've basically exhausted their appeals, and the judge is now going to talk about what to do about the negative ruling that they got.
So this is a massive ad system, Google's ad system. How does the government dole out a punishment for something this big, this wide-reaching?
Sure. Well, there's a couple of different ways. I mean, one is fines. So if there are consumers that were actually proven to be harmed, you can fine the company and then distribute those funds to the consumers who had damages. Another remedy would be to break up Google, the whole Google ad ecosystem, which is probably less likely because the internet is so dependent on that. And then the third option is to impose rules that will enforce, remove the monopoly powers that Google has and give more power to competitors so that they can compete in a fair marketplace for their services.
We do know this is not the only antitrust case that Google is involved in. What else has the DOJ gone after them for in recent memory?
Yeah, so in 2023, Google Play Store was found guilty of monopoly practices. Specifically with Epic Games was one of the main plaintiffs there. They lost the anti-competitive case, and because of the exclusive deals with developers and pre-installation requirements, et cetera, and that resulted in a $70 million settlement. Now, the other monopoly that's even bigger is obviously the search. In August of last year, they were declared a monopolist for the search business. And it's interesting, it wasn't search engines, it was queries on the internet. So it's a very specific category. And that's one of the challenges with these types of monopoly cases, because they literally had to invent a category. There was no standing common law history of cases that they could actually go back to. So they actually had to develop the case for what Google actually was and what it monopolized. And of course, that phase, as I mentioned before, is going to start on Monday with the remedy phase, and there are a lot of different options there. And normally with these things, the government actually looks to have a settlement because Google has billions of dollars in cash and they can spend as much money on lawyers as they want. So typically what they do is go to the company and say, here's what we feel the damages should be and here's our proposed remedies, and it's kind of worked out through a process. But not to discount the fact that the judge does have a lot of power in these situations. So depending on how the judge rules, and he was pretty specific on his criticism of Google's monopoly over search on the internet, and as a result, it's kind of an unknown right now what is going to be the outcome of that case.
Are there any other major antitrust cases that you're keeping your eye on right now? There are some pretty big names out there, right?
Oh, absolutely. I mean, two of the biggest ones that jump out are Amazon and Meta. Meta with Facebook, Instagram, WhatsApp. They're involved in a very intense antitrust case right now. And then also Amazon is being challenged for its unfair practices regarding small sellers on the Amazon marketplace.
One more thing before you go. You follow lots of these cases closely. How do these monopolistic tendencies typically start? Every case is different, sure, but have you noticed any common denominator that leads companies to act on monopolistic behavior?
Well, it's really an interesting question, Austin, and I think it's profound when you really think about it. Warren Buffett, one of the greatest investors of all time, says that he wants to buy businesses with moats around their business to kind of protect them in their marketplaces. So it's really a common drive for increasing profits. You have a tremendous year, and of course the board of directors is on your case to have an even better year the following year. So trying to gain different advantages in any way that you can is just sort of a common business practice. Obviously during the Gilded Age, the monopolies were very well known. Standard Oil is probably the biggest example of all. And breaking up Standard Oil actually not only benefited the consumers, but it also benefited John D. Rockefeller, because the sum of the parts was worth a lot more than the actual whole. So it's just a natural business drive, and it's understandable in one sense, but also when it harms consumers, that's where the government steps in and tries to bring about a remedy.
We'll be curious to see how exactly we see Google respond to this. As you said, an appeal process is likely. Tom Rossman is with the Henry George School of Social Science. Nice talking to you. We'll talk soon.
Thank you, Austin.